So I've been told that all of you are here to collect your licenses. Am I right? Okay, okay. Wishing you all the best. So this takes me back 37 years. I got my license in 1987 after passing out the law from the law college. At that time, from the Punjab University only. At that time, there never used to be 5 years courses. I think you all have passed out from the 5 year courses, right? Okay. 3 years also? Okay, okay, okay. Great. So I think this day is a special day for everybody. Either he wants to join the profession, for them it's more important. And in any case, those who want to pursue the rest of the things, somebody wants to come to the judiciary, want to sit in the competition examinations. So anyway, this license is for those who want to practice. This is what I believe. So how many of you want to practice, to win the active practice? Okay, okay, okay. Very less hands. So rest all want to pursue the competitions or what? Competitions? Okay. So you must be knowing that joining judiciary nowadays, it's a big challenge. As we used to call during the corona, the doctors were warriors. I would say in today's time, the judges are the warriors because of the pendency of the cases and the litigation which they have to handle. This is enormous. So very difficult for them to, take up the matters, and everybody expect that a judge would deliver justice. Of course, the judge is supposed to do that. But the amount of work or the cases which are piled up in the courts and which every judicial officer, I would say not only the district courts, not from the civil judge onwards, but right up to the Supreme Court, every judge is having hundreds of cases or thousands of cases to decide. And in case you take up in today's day, so since my main practicing center is the High Court, what I believe is that every judge in today's date has got about 200 and odd cases. And most of the times they are not able to take up all the matters in a day. So look at the plight of the litigants who feel that their cases even don't reach the number. But what to do? The solution is we have to have more and more judges. Perhaps I've been told by somebody that India is the only country, the developing countries or the developed countries, where no ratio as such has been fixed, that as per, like, for how much population there has to be a judge. The High Court, so in case we talk about our High Court, the sanction strength is about 85, and we are working in today's date almost about with 50, 54 judges. Every year the judges are retiring, new judges are not coming, and perhaps that's the reason for the backlog. That's the reason that we have got so much of pendency. And the same is the situation in the district courts also. Sometimes yesterday I was sitting in the Chief's Court, the court number 1, and a matter was going on that was with regard to as to the accommodation of the judicial officers in Punjab, Haryana, and UT Chandigarh. As you all know, that our High Court is for these two states and one UT. So therefore, the matter was combinedly taken up. And I was not surprised, I was rather shocked to find out that in case, suppose, in one particular district, there are about 50 judges, including your civil judges, junior division, senior division, then you have the ADJs, then you have, of course, a district judge. Suppose there are 50 judges in total in a particular district, and this happens only in big districts, maybe Ambala, we can say Amritsar, Ludhiana, Jalandhar. The shocking part was that it was told that the accommodations available are hardly about 20, 25, 30. And out of those accommodations also, most of the accommodations are under repairs, major, minor repairs. So what I'm trying to say is sorry, please don't take it that I'm distracting anybody not to join the judiciary. I'm just sharing with you the challenges in today's date by the judiciary who are to do, I would say, the main job. Of course, it is of the bar and the bench both. The assistance has to be equally from the bench also, from the bar also, in case we want our judges to decide the matters. But what I'm talking about, the limitation of the time which the judges have. So for all those, at least those who want to join the profession, I would say it's a very noble profession. When I joined the law department in 1984, I still remember that I joined only for the reason that I want to have more and more time at my disposal so that I can sit in some competitions. But after joining law, it so much fascinated me, and especially those, because I'm the first generation lawyer, nobody in the family was ever into this profession. So after joining law, I never looked for sitting in any competition. And after passing, in any case, after passing out in 87, for 1 year, I was in the district courts here in Chandigarh itself. Then I thought that I should go to the High Court because that was my ultimate goal. In 88, I joined the High Court. From 88 or from 87, you can say, when I took the license, as I said, 37 years have gone by. The transformation which has taken place in these 37 years, this is enormous. Whether this transformation is for good or bad, I really can't judge that. But all the same, what I feel is that there are many things where the casualties have taken place. The decorum, which is very close to my heart, this topic, in fact, the whole how to maintain the decorum, what should be your honesty, integrity, this should be the hallmark. But although maybe the transformation is enormous, but the hallmark of the profession, that is honesty, integrity, your hard work, your dedication, this remains unchanged. Those who stick to these principles, for them, this is a beautiful profession, I would say. Of course, the challenges are there, challenges in the shape of, I used to say that to my associates also, there are three P's. That's how to procure the work. That's the first P in this profession. The procurement is a big challenge. Then you have to prepare a matter. Suppose you have been engaged in a matter. That means you have procured a work for yourself. Then you have to prepare the matter to the best of your ability. And in case you are the first generation lawyer, or even if you are in somebody's office, or even if you don't join any office, my advice to you would be that never, ever feel shy of asking your senior about a particular proposition. And at least I have never seen a senior lawyer, maybe a senior in age or maybe a designate senior, that he would ever say no to any of his colleagues to help him out in the proposition. So of course the last P would be to perform. This is also equally important. Procurement, preparation, and then performance. Performance before the judge, as I said, to the best of your ability. Of course, result matters. But once you're arguing a matter in the court, I feel you should never bother about what the result is going to be. Once you have accepted a brief, thereafter, of course, your commitment to the client is always there. That will remain always there. But all the same, after taking a matter, you will have to prepare the matter in such a way that ultimately you have to see that what answer you are going to give to your conscience at the end of the day. That whether you have just done the justification with the brief or not. This is your own conscience which should tell you that yes, of course, you have done your best. So maybe, as I said, result may be any. That's in the hands of the God or in the, I would say, the luck of the client. But you should never bother for that. Maybe somebody will say that after spending 37 years, it's easy for a senior lawyer or for a lawyer to say that don't bother about result. For the reason, as in the younger days, as I said, I am the first generation lawyer, the results used to matter. Suppose some officers started giving you the work, and in case one failure after the other, you keep giving him the failures, he would never give the work. But I was lucky that those who have reposed faith in you, who feel that, yes, this lawyer can deliver, he would never leave your hand. At least I'm lucky that way. So the young lawyers, this is what my advice to you is. And the most important thing is to maintain the decorum in the court. Decorum is utmost importance. I always look for a platform to say that in case the lawyers you expect lawyers to maintain the decorum, It is equally a responsibility of the judge who is sitting at the bench to see that his or her court decorum is being maintained. Because in case we don't, since we are the part of the system, integral part of the system, the judicial system, in case the decorum is not being maintained, what kind of a message we are going to convey to the litigants, you can very well imagine. You often will see in the court that without this mobile, you really can't, I would say in today's date, whether somebody in the profession or outside the profession, very difficult to live even an hour without, what to talk of an hour, maybe for 5 minutes without this phone. And in most of the courtrooms, rather I would say in all the courtrooms, it is being mentioned that you are not allowed to take the mobiles in the courtrooms. I'm just giving an example for maintaining the decorum of the court. I have seen many lawyers, and I feel sorry for my colleagues, that in the court which is in session, they will just pick up their brief, they will keep the brief like this, and they will start hearing and they will attend the calls. Now look at the plight in case some litigant is your own client, is sitting at the back. He would say that for me, in case I use the mobile, my mobile is going to be taken by the court, or I will face some consequences. But the lawyer, who is an officer of the court, he's doing it. So what impression you are giving to the client? So that is why I'm saying maintaining decorum, your honesty, your integrity, your hard work, your dedication is of utmost importance, no matter whether you're a first generation lawyer, you're a second generation lawyer, doesn't matter at all. As they say, this profession is a zealous mistress. Nothing like that. At least in 37 years, I have never seen that. For the reason, you get so many holidays in this profession. Just like the school children or the college children, college-going children, they have all the fun and all the holidays. You can always enjoy whatever you earn. You have ample time to enjoy. You have ample time to give it to the family. Maybe that's, of course, it's a more demanding profession. From morning till evening or till night, you are busy in the morning. Once you get up, you prepare for your the matters which are listed on the same day. Then you are in court from up till 4 or 5 o'clock. Then you come back, take a rest for about half an hour, and then you are again in the office. And you remain in the office till 9:30, like depending upon your nature of work or the amount of work. But all this, having said that, since you have enough of holidays in your profession, so you can enjoy whatever the backlog of, I would say, the homework with your, maybe the partner, maybe your children, they look for that you should give them time. So you can always say that we are going to get the holidays. You'll have enough time to enjoy with us. So now I just wanted to touch on this topic, although this is not of today's lecture, nothing to do with that. But since it is very close to my heart, as I said, so I wanted to touch on that for 10 minutes. Now coming to the lecture for which I have been called upon. So this is, as we all know, that we are celebrating the 75th year of our Indian Constitution. And today's lecture is for Dr. B.N. Rao's, his complete name. Of course, he had a doctorate degree, so therefore he's called Dr. B.N. Rao. But his full name otherwise is Dr. Sir Benegal Narsingh Rao. Why Sir? Because he got the knighthood in 1948. And we all know that what is knighthood. Knighthood is I would say it's a sort of the king or the queen of England. They bestow upon a citizen of any country a title or an honor for the distinguished services which they have rendered for their own country. So it is because of the services which Dr. B.N. Rao had rendered for India. It is for that purpose that he was given the knighthood title by British government. Although 1947, we all know that we got independence from the colonial system. And 1947, when we got the independence, thereafter the big challenges, of course, when we were about to get the independence, there were two big challenges. One was to make the Constitution of India. And I am sure that most of you have read all Constitution in your semesters, one or the other semesters. the Indian Constitution is the largest constitution and the most powerful constitution in the world. If I'm permitted to give you a bit of details about this constitution, since I couldn't remember these figures by heart, so therefore I had to scribble down. This constitution has got 448 articles, and they are grouped in 25 parts with 12 schedules. Originally, when the constitution was brought in, there were only 395 articles, and this was in 22 parts and 8 schedules. And by virtue of 104 amendments, this article number has swelled from 395 to 448, and 12 parts has gone to 25 parts, and schedules have gone from 8 to 12. Now, the task was very big for framing the constitution. And the second task which I was talking about, the second uphill task, was that we had about almost 562 princely states in our country. Like Patiala is also princely state, Hyderabad was a princely state. So the two things which we were looking for to how to make the constitution, there was, in order to get the constitution, there was a constituent assembly who had to make this constitution. And for that reason, the person who was at the top was Dr. Bhimrao Ambedkar. We all know that he's the father of the Constitution of India. He's the one who led the team, the drafting team. And there was one or two backroom boys. Why we call backroom boys? Because whenever you achieve something, there is always two type of players. One is the front runners, who are the front players we call them. And the second is who play from the back, as we call the back singers also. So this Dr. B.N. Rao used to be famously known as the backroom boy for the Constitution. He was an advisor, in fact. And as I said, for this purpose, for Constitution, Dr. B.R. Ambedkar, and for integration of all these 562 princely states, Dr. Vallabhbhai Patel, he was the one who was the first Home Minister of India eventually. He was the one who really was a front runner to see that all these princely states are integrated together. And Hyderabad princely state was the last princely state which was brought in this integrated plan, and that all happened in September 1948. But here the journey starts of the making of the Constitution. So this Constitution of ours, this was drafted, before that, if I am permitted to say that, Dr. B.N. Rao, I don't know whether you people know it or not, Dr. B.N. Rao was a very helping hand. I would say rather he was the one who made the Constitution of Burma also in 1947. So Burma, we know it's called Myanmar nowadays. So he was the person who got the Constitution of Burma also made. So our Constitution was adopted on 26 November 1949, and it became effective from 26 January 1950, and this is how we are celebrating 75 years. Now, look at the life of Dr. B.N. Rao, a very distinguished, I would say, and a very decorated life which he had led all the time. Just at the age of 23 years, he became an IS officer. At that time, we used to call it civil services. Nowadays, also civil services. His date of birth is 26 February 1887. So 1910, that is exactly after 23 years, he was the IS officer. Before becoming an IS officer, he was a graduate from the Madras University, and then he joined the College of Trinity in Cambridge. Thereafter, he got enrolled, as I said, in the Indian services in 1910 at the age of 23. Then from 1935 till 1937, he was a person who revised the Indian Statutory Code. And in 1938, as I said earlier, that he got the knighthood. From 1939 to till 1944, he remained a judge of Calcutta High Court. At that time, of course, the seat was Calcutta, but as we call it nowadays as the Calcutta High Court, it was Bengal High Court at that point of time. Then 1944 to 1945, he remained even the Prime Minister of Jammu and Kashmir. Then 1947, he helped drafting Constitution of Burma. Then from 1950 till 1952, he remained the permanent representative of India to the United Nations Security Council. And from February 1952 till his death, he remained a judge of International Court of Justice at Hague. At that time, it was called the Permanent Court of International Justice, The Hague. And his important work, of course, besides, I said, he was an advisor to the Constituent Assembly. His writings on Indian laws involve noted study on the constitutional precedents, as well as articles on human rights in India. Now, coming to the constitution of our country, as I said, this constitution is having all kind of things in its fold: your fundamental rights, your fundamental duties, directive principles, and so on and so forth. These citizens must talk about their fundamental rights. I would say that before claiming some fundamental right, you have to remember that what is your fundamental duty also, which have been set forth in the Constitution. There's only one section, Section 15A, Article 15A in the Constitution, which talks about the fundamental duties. Of course, so for the fundamental rights are concerned, we all know that it all starts from Part 3, those are all fundamental rights. And look at the rights which the Constitution has granted to us. This is the right of equality, then right of freedom, then we have the rights against exploitation, then we have right to freedom of religion, then we have got cultural and educational rights, and one of the last right is right to constitutional remedies. Talking about fundamental right and connecting it with Dr. B.N. Rao, as I said that he was an advisor when the draft policy was made of the Constitution of India. In the draft policy, when Article 21, with regard to your life and liberty, which is the most, I would say, the important fundamental right available to all the Indian citizens, the debate was, if you permit me to read exact words, just two sentences of Article 21. This says, protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to the procedure established by law. Now the debate was in the draft policy, which was prepared by Dr. B.N. Rao, the word used at the end, that except according to the procedure prescribed by law, it was that except in due process of law. It was quite a debatable issue whether it should be except in due process of law or these words should be used. So in his wisdom, Dr. B.N. Rao thought that it should be except in due process of law. After, this is what I read in the article, this is what I'm sharing with you people, that after drafting this, the first draft, or we could say the rough draft of the policy, of the Constitution, Dr. Rao went to US. In the US, he met one of the judges of the Supreme Court. His name was Frankfurter or Frankfurt. So he had a detailed discussion with him. So this is from his advice that he was told that no, you should not use the word except in due process of law. The word appropriate would be that it should not be except or according to the procedure established by law. There is a story behind it, which I really don't want to share at this point of juncture. But this is how, when the final constitution or when the final draft came in, so these words were used instead of the except for due process of law. Now, Article 21, besides Article 21, as I said, there are other various articles with regard to your right to religion or right to freedom of religion. Freedom of religion is again a very important part in our life, especially in today's date. We daily see that in the name of religion, there are all sorts of problems in our country. Although it's a very sensitive topic, I should not touch upon it much, but except to say that once we say that our country is secular, then in that eventuality we'll have to have faith, belief in every religion, and we should allow every citizen to practice his religion the way he wants. And this is what this right to freedom of religion is involved. I did a matter a few years back. There is one, maybe you people know who are from Punjab. There is one place called Noor Mahal. One Ashutosh Maharaji, he is one of the head of the sect. And the belief of the sect is, I was representing the sect in that matter. The belief of the sect is that Ashutosh Maharaji has not passed away. And he is going to get rebirth in the same body which they are still keeping. He is going to get a rebirth in that. Or when we prepared the matter, it used to be that there's a very thin thread between the mortal, which is lying here, and in the sky where the Ashutosh Maharaji has gone. So that from that thin line or the silver line, he was going to come back to the mortals. This is the belief of the sect. And we won the war, like on the other side, there were villages, there were people who were not belonging to the sect, who were not having belief in the sect. Their version was, no, since he has passed away, so therefore, a person who is dead, he also equally enjoys the same right of under Article 21. His mortals should be put to flames, or whatever way they want to bury it, that should be done. But this was a long-drawn battle, which ultimately was won by the sect, saying that it is a belief of the faith, belief of the faith of the sect. So therefore, it is that belief which has to be kept alive, and for upkeeping that, the judgment came in favor of the sect. So what I'm trying to say that if you look at all the fundamental rights with regard to equality, Article 14, 16, so beautifully written, that's a different thing, that in how you get it implemented before the courts of law. As we all know, separation of powers, this is the best part of our constitution. You have the powers are lying with three different agencies. One, of course, is the legislative power. That is to legislate the laws. The courts do not legislate the laws. So the three heads under which separation of powers is there. One is the legislation, where the legislation is to legislate the law. Second is the executive, who are there for enforcing the laws. Executive agency is that. And the third, of course, is the judiciary. Judiciary is to see that the laws which are being made by the legislation, they are being implemented in a proper way. Wherever the judiciary has tried to cross a line, or for that reason, all these three different heads, where the separation of powers is very clearly defined in the Constitution, wherever any one of these three have tried to cross their border or cross the line, it has been checked. In case, suppose, I just give you an example. As the courts do not frame the law, courts simply interpret the law. But at the same time, in case, while giving some judgment, the court feels that the law is not good, they can always strike it down. But suppose some judgment has come, and in order to overcome that judgment, in case they want to make the law, suppose some judgment has come against the government, and the government wants that in order to overcome this problem which has come in our way, we should legislate in such a fashion so that to make this judgment itself obsolete. There also the courts, whenever the new law is being made, it is not like that the courts can shut their eyes, or the courts are of absolutely no help to the public at large. The courts can still strike down the law, holding that this is against a judgment. So this is what the beauty of our Constitution is. The Constituent Assembly, many times the question arises as to what we call as a constitution. The Constitution, in fact, is a set of laws that legally represent the ideals of a state. Or we can say this is the fundamental laws that govern the law of a state, or the state is being run with those laws. And constitution, it's not like that it has to be only a written constitution. There are many countries who do not have the written constitutions. But you can very well understand if there's no written constitution, what kind of a chaos can be there. And I have come across, while studying on this topic, it was again a surprising thing for me, that many countries are those where constitutions are more than one. In one of the countries, there are more than 20 constitutions. But since our country is so big, democratic country, having such a powerful constitution, it is only because we are having a large population, religions which are far, far in number. In order to bring them together, this is what the attempt has been made, to frame this kind of a constitution so that everybody can look upon and everybody can follow as to what the principles of law have been laid down in the constitution. Those who want to practice, now this is broadly I said about the constitution, because I'm sure that since you all have studied constitution as one of the subjects in your semester systems. So for coming to the practicing the constitution in the courts, so for the district courts are concerned, those who want to start the practice in the district courts, I would be very honest with you people, that constitution is never being looked upon or never being taught or even referred to. This is what my little knowledge about the courts in the district courts are concerned. So for high courts are concerned, in high courts also, the scope of using the constitutional provisions of various articles is very, very limited. Mostly we file the writs under Article 226 because the original jurisdiction of the High Court is in the shape of writs. Writ of mandamus, writ of certiorari, quo warranto, then prohibition, all these 5 kind of writs are there. So for that, you have to come to the High Court under Article 226. And in case you are to go to the Supreme Court straightway, under Article 32, you can straightway go to the Supreme Court by filing a writ. Otherwise, in case you are to file a writ in the High Court, then in that eventuality, although my analysis may be wrong, but my analysis are that most of the writs are confined to the violation of the principles which are, or the fundamental rights which have been enshrined under Part 2 of the Constitution, that is Article 21, Article 14, Article 16. Then of course, one very more important right which has been given is right to profession or right to business. This is under Article 19. So in case somebody's rights are violated, somebody has not been right to carry on the business which he wants to do, or the business is being disturbed by any act of the state, then in that eventuality, you come under for violation of Article 19, again under Article 226. And of course, suppose there are election matters, elections with regard to municipal corporations, panchayats, again there is a different chapter devoted in the Constitution, and for that also you can come to the High Court. Except for these limited articles, I have never seen in the High Court using many other articles by filing the writs or when the writs are being argued or decided. But of course, in the Supreme Court, it is the Constitution alone which is being, in every case, whether this case emanates from any of the high courts or it is straightway filed in the Supreme Court, all these matters in the Supreme Court, there is only one, I would say, they first ask for that whether a lawyer is a constitution expert or not. Because in Supreme Court, Constitution is a prime subject. You have to bring in your case within the fold of some violation that, of course, maybe Article 21, Article 14, 16, as we do in the High Court also. But what I want to say is the usage of the Constitution is much more in the Supreme Court. And in case, now this is what I could talk to you about with regard to the Constitution, Dr. B.N. Rao, his whole, I would say, the life, which was full of, I would say, decorated life he had, right from the age of 23, when he became he joined the administrative services, and right up to the date of his death, when he died while being one of the judges of the International Court of Justice at Hague. The footprints which he has left, only those persons are remembered in this, I would say, history, who leave their footprints. And he is one person, maybe he was playing at the back, never a front runner, but all the same, his contribution in the constitution to be made of India is much more than anybody else. And this is how we remember this personality. And our salute to the persons who have made a constitution for which we every day, the lawyers or the whole public thrive for or they yearn for. And I believe that this is what I had to share with you about the Constitution, about the person who had a major contributory to the Constitution. If you have any questions, you can ask me. And best of luck to all of you. Yes, please.
Good afternoon, sir.
Yes, very good afternoon.
So you talked about Ashutosh Maharaj's case, but then an instant case which comes to our mind is Sabrimala case of the Honorable Supreme Court.
That's right.
Then you, in Ashutosh Maharaj's case, you talked about the main reasoning that there is a belief system of the believers, whereas the petitioners in the Sabrimala case were also people who were non-believers, Young Lawyers Association.
That's right.
And the dissent in that talked exactly about that religion is about faith, and it does not really see the reason. And that was a dissent. But the case that you won in the Honorable High Court was one on the reasoning which was the basis of the dissent, but the majority judgment was that the fundamental rights have to be respected foremost, and the right to religion will also have to conform to the fundamental rights.
Absolutely.
So what are your views? Because they don't reconcile really.
Look, if you see Article 28, I think that's with regard to the right of freedom. What Article 28 says, your answer to your question that lies in the article itself. I will just read this article to you because that was the matter in issue. This freedom of religion, this section starts from Article 25. It goes right up to Article 28. Article 25 says freedom of conscience and free profession, practice and propagation of religion. Then Article 26 talks of freedom to manage religious affairs. Then Article 27, freedom as to payment of taxes, that's not really required for your question. Freedom as to attendance of religious instructions or religious worship in certain education institutions. That, of course, is not the article which is related to your question. So, once you read Article 25 and 26, subject to public order, the article itself starts with this, subject to public order, morality and health, and to the other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice and propagate religion. So unless and until you don't remain within the bounds of public order, morality and health and various other provisions of this part of the Constitution, so meaning thereby that there is boundaries which have been created within the article itself to profess the religion. No right, I would say no fundamental right is absolute in itself. You have a fundamental right to speech also. But right to speech also, that doesn't mean that you can speak anything, anywhere, which is a nuisance to the other people or which is annoying to the other people. That way, every right, I would say somebody say that I have got a right to life and liberty. That doesn't mean that right to life and liberty would be at the cost of the equivalent right which is given to the other party or to the other citizen. So therefore, the judgments are always based upon facts. As you said, Sabrimala case, we really can't equate that case with the case which I talked about, Shri Ashutosh Maharaj. For the reason that, as I said, every case has its own facts on the basis of which the matter is being decided. Here also, in Sabrimala case, I will be very honest with you, maybe the facts which are there may be different from this case, But all the same, the underlying principle of all the judgments, whether it's a Sabrimala case or for any other reason, Article 28, 29, is one that the right to practice religion is not an absolute right. That again saying that maybe suppose I want to have I have a faith in one particular religion, and then I start saying that no, the other religion is not good. That is not the scope. That you have to, by professing your religion, you have to condemn, or you should condemn the other religion. As I said, everybody has his own faith, everybody has his own belief in a religion. So therefore, you have to remain within your bounds, and the exceptions which have been carved out in this article itself, those exceptions are the checks and balances upon professing and practicing a faith or religion. This is what I can say about that. Anybody else? Right. So wishing you all the best once again. So whichever profession you want to pursue, whichever career you want to pursue, so do it with full dedication. This is what I can say. And be honest to yourself. This is more important. People say that you have to be honest, your integrity should be above board. In case you are honest to yourself, you are definitely honest to the others as well. Thank you so much. Wishing you.